Hi everyone and welcome to our Ius Laboris coffee break where we discuss the important employment and labour law developments from across the world. Today I'm joined by Gisella Alvarado from our Spanish law firm within the Alliance, Sagadoy. Lovely to see you, Gisella.
Thank you very much, Alex. It is a pleasure to be here with all of you.
Brilliant. Thanks, Gisella. And it's worth noting that Gisella is our chair of our individual employment rights expert group, and so is a real specialist in that sort of area. And one trend that we're seeing around the topic of individual employment rights, especially in Europe, but also further afield in Latin America, is this point on the reduction of working time or the maximum working time. This seems to be a point that's come up in Spain recently, Gisella. Maybe you could give us a little bit of an update of what the latest is around this.
Yeah, absolutely. Well, in Spain, we have a draft bill which proposes to reduce the current maximum working time of 40 hours per week to 37.5 hours per week on an annualized basis, without this measure implying any kind of salary reduction for employees. It's also very important to take into account that this potential reduction of working time will have an impact not only on full-time employees, but also on part-time employees. In particular, the draft bill states that for those part-time employees performing a working time equal or more than 37.5 hours per week, they will be automatically converted into full-time employees. And also the draft bill states that for those part-time employees working below the new maximum working time of 37.5 hours per week, they will receive a salary increase proportional to the new maximum working time. So quite interesting, not only for full-time employees, but also for part-time employees.
Really interesting. And so it's a bill at this stage. So what do employers need to be aware of at the moment?
Okay. At this stage, employers must bear in mind that this is a draft bill.
Yeah.
It has not become effective yet. Although the draft bill has been approved by the government, it is still pending to be debated and approved by the parliament, and consequently, new modifications could be introduced. In any case, at this stage, it would be advisable for employers to, first of all, determine, verify, check the collective bargaining agreements that applies to the companies. Why? Because usually these collective bargaining agreements regulate maximum working time below the statutory maximum working time. So, first step, they will realize, in fact, the real or the actual numbers of hours that employees will no longer work. And then, on the basis of this information, determine the potential impact on full-time employees, part-time employees, and also those employees who have exercised their rights for working time reduction, as it would be the case of the employees with working time reduction for childcare purposes, for example.
And so, Gisella, this new bill, does it have any mechanism to enforce compliance with the reduction of the working time?
Yeah, indeed. The draft bill intends to modify the current legislation on the working time recording system. Just for your information, from 2019, there is a mandatory obligation in Spain, which imposes on employers the obligation to implement a working time recording system, where employees must record their working time on a daily basis. Generally speaking, and just to make a very brief summary, Spanish law right now states, first of all, that employers are free to choose the type of working time recording system. So they could decide if this recording system is manual, digital, or electronic. Then, current law states that the employees are obliged to record only the start time and the end time of each working day. Of course, it is advisable to also register any kind of interruption or break during the working day. Then, current legislation also states that the records of this recording system must be available not only to employees, but also employees' representatives and to the labor inspectorate. And in terms of enforcing compliance, it established that the lack of implementation of this recording system could lead the labor inspectorate to impose on employers an economic fine up to 7,500 euros approximately. Okay, so this is the current legislation, but the draft bill may change these regulations, mainly according to the draft bill. Okay, first of all, the recording system must be electronic or digital. That's the first thing to take into account. Then it would not only be mandatory for employees to record the start time and the end time, and also the interruptions and the breaks during the workday, but also employees would have to identify the regular hours and the overtime performed every day. On top of that, the government wants the labor inspectorate and the employees' representative to have remote access on the working time recording system. And on top of that, the draft bill also states that the lack of implementation of this working time recording system will not only lead to the presumption that all the hours, regular hours, and overtime claimed by the employee would be considered to be performed, but also the economic fine that the labor inspectorate could impose on the company could amount up to 10,000 euros per affected employee. So relevant figures, relevant information to be taken into account.
Wow, really interesting, Gisella. So we've obviously spoken about how the bill deals with the reduction of working time and working hours. I've also heard that it deals with the right to disconnect. Perhaps you can tell us a little bit more about that.
Yeah, that's an interesting question. In fact, Spanish law has recognized to employees the right to digital disconnection. And in particular, the draft bill states that, first of all, employers will not be able to request employees to work outside the regular working hours, of course, with the exception of overtime, if overtime has been agreed by the parties to be performed. But also the draft bill states that the employees could not be contacted by the employer or by any third party with a commercial relationship with the employer. Okay, so this is quite interesting. Of course, there are some exceptions that could be taken into account, but basically what the draft bill says is that by collective bargaining, it will be established those exceptional cases that will allow employers to communicate with their employees outside the regular working hours. Mm-hmm. And mainly, these exceptional cases refer to, from one side, if there could be a serious risk for the employees, or if it could be a potential serious damage for the company. But as long as the communication to employees is absolutely necessary because the company requires an urgent and immediate action. So a lot of new information. We don't know what's going to happen. As we mentioned before, this draft bill is pending of debate and approval from the parliament. Mm-hmm. But well, these are basically the lines from the government. We have to make a follow-up on this matter, and it will be a pleasure to organize another coffee break session once we have the final regulation on this matter.
Yeah, absolutely. I mean, it's very important that employers with operations within Spain are aware and know what's coming down the track. So yeah, really, really interesting stuff. Brilliant. Well, thank you so much, Gisella.
Thank you very much, Alex, and thank to all of you. Thank you very much.
Thank you.